A criminal defendant is afforded an opportunity, pursuant to Penal Code Section 995, to attack a judge's order binding them over for trial in the Superior Court. A Penal Code Section 995 motion allows the criminal defendant, through their attorney, to attack the sufficiency of the evidence of the preliminary hearing. It's an extremely critical and important tool for a criminal defendant, in that it allows their attorney an opportunity to say, as a matter of law to a new judge, that the binding order holding them over for trial made by another judge was insufficient under California law. Oftentimes, we can argue in a 995 motion that the evidence simply is not sufficient against this particular defendant, or the information that was presented does not lead to a holding for a felony for trial. It's our practice here in the Inland Empire that whenever we do a 995 motion, if it's possible, we will also do what's called a 17B motion. A 17B motion is to reduce a felony, which is the most serious type of criminal matter, to a misdemeanor, which is less serious. And one of the great parts about doing these concurrent motions is this. Oftentimes your 995 motion, it may be a close call, and judges who are often conservative, and many times former DAs, will lean toward not granting that motion. However, if you write a valid 995 motion that truly is a close call, and the judge goes against our client in that regard, they may then grant the 17B motion to reduce the felony to a misdemeanor. There are numerous factors that make up a successful 995 motion. Oftentimes, it's attacking the witness's credibility, showing that they were impeached, or showing that applicable law doesn't support a felony charge based upon the evidence that was presented at the preliminary hearing. Now, the district attorney may get a second bite of the apple, so to speak, in that even if the 995 motion is granted by the Superior Court judge, the district attorney does have an opportunity to file one additional time those same charges. Our office at any given time is handling 5 or 6 995 and 17B motions. We feel it's a critical component of our practice in that we want to let the DA know when we litigate a case on behalf of our client, we're going to litigate it to the fullest extent of the law and use every available resource of the law to attack the district attorney's case. I'm Mike Scaffidi, a retired police officer and now a criminal defense attorney with Schaus Law Group. If you or a loved one are in trouble and need help, call me.